Tuesdays and Thursdays. If you're getting CLE credit, be sure to sign in the back for that. Next week, the schedule is going to be a little different. We're doing a Wednesday, Thursday schedule next week. It's the only time that happens during the summer, so just note that. Today, we're pleased to welcome Yvonne Scannell. She's the professor of law and director of the she was a professor of law and director of the Center for Environmental Law and Policy at Trinity College in Dublin until 2014. She now practices law with Arthur Cox, the leading environmental law firm in Ireland. She has written 6 books and numerous articles on environmental law, natural resources, planning law, and some on constitutional law. She has been consistently nominated as one of Ireland's leading environmental lawyers in chambers and other professional surveys. She is a judge and vice president of the European Nuclear Energy Tribunal. And she is a graduate of Trinity College, Dublin, and Cambridge University, and the recipient of an honorary degree from Washington and Lee University. We're lucky to have her at VLS. This is our second year with Yvonne, Professor Scannell, teaching European environmental law. And today she's going to be presenting Human Rights and the Environment in the EU, the evolution of a right to environmental protection. So she'll speak, and then we'll have a short Q&A period and get people out of here by 5 minutes to 1, so you can get to your classes if you need to. And before we turn things over to her, I'm going to give us our poem of the day. Some Glad Morning by Joyce Sutphin. One day, something very old happened again. The green came back to the branches, settling like leafy birds on the highest twigs. The ground broke open, as dark as coffee beans. The clouds took up their positions in the deep stadium of the sky, gloving the bright orb of the sun before they pitched it over the horizon. It was as good as ever. The air was filled with the scent of lilacs and cherry blossoms, sounded their long whistle down the track. It was some glad morning. With that, let's turn things over to Professor Scannell.
Thank you. Thank you very much, Melissa, and thank you for coming here today. So I'm going to do a whistle-stop tour into what I consider to be the evolution of a right to the environment in Ireland. And I thought, as I have actually recalibrated what I was going to say in the light of recent developments in the US. But I was thinking about your Declaration of Independence, where it says, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. And in our system, we have interpreted the right to life and the right to happiness, which at that time I understand meant well-being, to evolve those rights into a right to a healthy environment. So just before the US said that it was withdrawing from the UN Human Rights Council, a submission was made to that council for a draft new covenant on the right of human beings to the environment. We're sort of hoping that this will be a follow-on on the International Covenant on Civil and Political Rights and the Covenant on Economic, Social, and Cultural Rights. But at least since February, it has been with the United Nations Human Rights Council. And in this draft covenant, it says, humankind is concerned with the dangers faced by human beings and nature due to the adverse effects of climate change, accelerated loss of biodiversity, natural and technological disasters, land, forest, and ocean degradation. These upheavals are all violations of human rights and represent serious threats to present and future generations. So this is in this draft covenant. And the fact is that when the environment has been degraded, other human rights become more difficult or impossible to achieve. The human rights to life, food, health, well-being, water and sanitation, all declared adopted human rights, are all dependent on a certain environmental quality. If I have a right to life, I have a right to the conditions without which I cannot live. If I have a right to water, I have a right to unpolluted water. If I have a right to food, happiness, health and well-being, I have a right of access to nature and to an environment that enables me to enjoy these rights. If my fertile fields are flooded or turned into deserts, or polluted, or affected by natural disasters, many of my human rights are violated. So it is important, therefore, to establish that there is a human right to the environment. And one of the reasons for this is that if something is recognized as a right, courts must enforce it. And public authorities must take account of it in their policies, programs, plans, and in their actions. So it does achieve a certain status, which means it's more likely to give effect to what it seeks if it is a right. And many millions of people today enjoy clean drinking water because of the constitutional right to a healthy environment, compel their governments to invest in infrastructure and protecting water supplies. And that just shows you that where a country has a human right to a clean environment or to a healthy environment, governments can be forced to take account of this right and to vindicate it. So in the EU, we have the following documents, which are such that you could say we are almost at the stage of having a human right to the environment. The EU treaties themselves. Now, we call these the EU treaties, but for you, it would be like the Constitution of the United States, right? But we don't call it that for political reasons. Some countries don't want to have a European constitution, but in fact we do, but we don't call it that. Another thing is the common tradition of constitutional traditions of member states. 11 out of the 27 member states have a right to a healthy environment, and some of the others don't. The Irish Constitution doesn't, for example, because it was passed in 1937. It was passed now, it would have, and we have evolved constitutional rights which effectively say the same thing. We have the European Convention on Human Rights, which is the most amazing convention and which has had a huge effect on human rights everywhere in all the 47 countries that are party to it, and also on environmental rights. And we have the Charter of Fundamental Rights of the EU, adopted in 2010, which is also has constitutional status. And we have the European Social Charter. And as well as that, international agreements that member states have signed and ratified all influence the growth of a right to the environment. And for example, all 28 European states have signed and ratified the Kyoto Protocol and the Paris Agreement. So the Lisbon Treaty, which is the constitution of the EU, says that union policy on the environment shall contribute to the pursuit of the following objectives: preserving the environment, protecting human health, and promoting measures at international level to deal with regional or worldwide environmental problems, and in particular, climate change. So we have actually written in our federal constitution a commitment to promoting climate change. And 11 of our 28 member countries make specific reference to the right to the environment in their constitution. And this illustrates a growing recognition that environmental protection deserves the highest form of legal protection, that is, constitutional protection. Now, the Charter of Fundamental Rights itself says, I think I may have, if you wouldn't mind me, I think I have the long version of this on that sheet. But wait, let's see, because I don't want to bore you with too many. Yes, it's the long version. Sorry, I have to get this. I'm sorry about this because I know I'd never be finished in time if I do. This is the one. Okay. Constitution, yes, the Charter. Now, this Charter of Human Rights, where we have adopted a high level of environmental protection, applies to the EU institutions, the Court, the Commission, the lawmakers, and to member states applying union law. And in the EU, almost all environmental law and almost all energy law is EU law. So we don't have, Ireland doesn't have specific Irish environmental laws. 99% of our environmental laws are informed by the Union. And the fact that the Charter of Fundamental Rights has rights to a high level of environmental protection and other requirements means that all member states have to give effect to their rights in their national jurisdictions. So, for example, there was an Irish case called Malak, where a Syrian man came to Ireland with his wife, and 7 years later she got a right of residence and a green card, and he didn't. And they wouldn't tell him why. So he brought a case to the Supreme Court and he said, I need to know why I am being deprived of a right to a green card, whereas my wife isn't. And Stephanie and I had dinner in his restaurant one night. And the court said that the Irish government said, we don't have to give you reasons. We need to keep these kind of things secret while we exclude people from our jurisdiction. And the court said, no, the European Charter of Human Rights says that there is a right to good administration. And the right to good administration means that people who are affected by decisions have a right to know the reasons and reasoning for those decisions. So as a result of that, and that right in the Charter, all public authorities now in Ireland making decisions which could affect people's rights have to give the reasons and reasoning for their decisions. So that just shows you how important it is to have a right in a charter. So we talk about how have we a growth of this right to the environment. And it started really in the United Nations Declaration on Human Rights in 1948, made after the Second World War, where many human rights had been atrociously violated. And it said in that Article 25 that everybody has a right to a standard of living adequate for the health and well-being of himself and his family. So how can you have a right adequate to your health and well-being unless you have a good environment? And in Stockholm it says that man has a fundamental right to adequate conditions of life in an environment of a quality that permits a life of dignity and well-being. And after Stockholm in 1972, the European Council said, from now on, we are going to take the environment into account in our policies. And in 2009, we incorporate a standard of a high level of environmental protection and a commitment to climate change in our federal constitution, as it were. In addition to that, we have accepted the rights declared, the procedural rights for ensuring a good environment in the Aarhus Convention, the rights to information, public participation, and access to justice, have been incorporated into what is called the European acquis. The European Court has said in the Brown Bear case that in applying their policies, member states must do their utmost to give effect to those rights. So that's what has happened so far. Now, the most important, actually, something's gone wrong with this. I'll have to talk to you about it. The most important convention is the European Convention on Human Rights, which was adopted after the Second World War. And although it's called the European Convention, it actually has 47 countries parties to that convention, including Russia, Turkey, countries where you wouldn't expect that they would accede to this convention. And in this convention, there are a number of rights which have been interpreted by the European Court of Human Rights to vindicate environmental rights. The first of these is the right to property, which you wouldn't think was relevant in interpreting environmental rights. But that right has been relied on, for example, to give a woman a right to recover possession of her property because the Italian courts would not enforce her right to possession of her property. The length of proceedings were so long that it deprived her of her right to property. The second article in that convention, which has been interpreted very widely, is the right to life, the one which is in the American Declaration of Independence. And the right to life has been used to make sure that member states warn their people of imminent dangers to their health. So, for example, there was a case called Gera and Italy, where this village was next to a fertilizer factory, which was causing very bad pollution, which was affecting the health of the people. And nobody told the people that this was why they were suffering ill health. And somebody brought a case to the European Court of Human Rights which said that in those circumstances, Italy was obliged to warn people of the danger to their health and to take action to ensure that their health would not be endangered. There were other cases of nuclear trials in the 1950s where the British authorities tried out some nuclear tests. Some soldiers suffered as a result, and the daughter of one of them, who got leukemia, sued the British state and said, "You should have warned us in our family that we had health effects from what had happened." Now, it happened that the court said in that case that at the time the explosions had happened or the trials had happened, the British authorities did not know that radiation would have those effects. And as a result, they were not obliged to tell the soldier at that time. You wouldn't say that now, but it was. There was a Swiss case brought to the European Court of Human Rights about a man who died as a result of exposure to asbestos. He sued for damages in the Swiss courts. They said you can't do it. You had 10 years to sue from the time the exposure happened, and it is more than 10 years now. He brings the case to the European Court of Human Rights, and the court says that this is unfair. The time limit for suing should be dated from the time you discovered the illness, because it wasn't discoverable. So it should go from that time. So the right to life has been expansively interpreted to force states to warn of dangers, to protect people against dangers, and to change their laws so that people would not be deprived of opportunities to vindicate their rights to life. Now, another article which has had a huge influence on the development of a right to a healthy environment is the right to private and family life. Article 8 of the Convention says, "Every person shall have a right to respect for his private and family life." And when that was enacted, everybody thought that means the state can't open your letters or the state can't invade your home. But it has been interpreted to mean that humans in Europe are covered by the Convention are not to be exposed to severe pollution. And the first case where this happened was a case called Lopez, Austra in Spain. This woman lived within 30 meters of a wastewater treatment plant. It was malfunctioning. It was half owned by the municipality, half privately owned. And she suffered bad health effects. She tried to get a remedy in Spain. She couldn't get it. She goes to the European Court of Human Rights, which says that her right to private and family life was violated by this air pollution, which was affecting her health, and that she had a right not to be severely polluted. And even other cases, or even starker cases than that, 33% of Europeans are exposed to road traffic noise higher than 55 dBAs at nighttime. Now, 55 dBAs is high enough. It should be 45 ideally at nighttime, right? 55 during the day, but 33% of them. In one case in Austria, people objected because they said the noise from the motorway was above the legal standards. Now remember, motorways are built by public authorities. They're built by the state. The state doesn't like having to admit it was wrong, and so on. And the European Court said that that was a violation of their rights to private and family life, and made orders that the state was to vindicate their rights and to ensure that the decibel levels were reduced. There was a case in Spain. This woman lived in a Spanish seaside town. She was driven bananas by the noise of the discos every night. Any of you who've ever been to Spain know that dinner is at 10 p.m. Americans would never understand this, right? But dinner is at 10 p.m. and the discos stay open until 3 or 4, right? And there were 47 discos in the town, right? And people, the residents were going nuts. So they go and say to the local authorities, close down those discos, bring in standards. And the local authorities wouldn't do it because they said, it's only for the tourist season. Everybody depends on this for their livelihood. You mustn't do this. And so they wouldn't give her a remedy. So she goes to the European Court of Human Rights. The European Court of Human Rights says, that is exposing her to severe pollution. That is a failure to vindicate her right to private and family life. And as a result, it made an order that Spain couldn't do that. It was a Russian case. In Russia, there was a tailings pond which was up in a mountain. Everybody knew things were wrong with the tailings pond. Nobody was doing things about it. Then one day, the inevitable happened. It broke, all the tailings came down in a village, several people died. Question was, were their rights to life and to private family life were violated? But the interesting thing in that case was that the court said that not only were the Russian authorities in violation of people's rights, but they had an obligation to monitor dangerous installations. They had an obligation to have a regulatory system which would not allow this to happen. And they had an obligation to assign responsibility for what went wrong. So you can see the layers and levels of intrusion in the administrative systems in the member states' countries, but how this was going to be very effective in future if you were going to assign responsibility for what had gone wrong, if you were going to require a proper regulatory system. In Turkey, I don't know if you remember about the earthquakes in Turkey. There were earthquakes in Turkey. All these buildings were demolished. The question was, why were they demolished? Reason, they did not comply with building standards. They were not earthquake proof. The people were killed, people suffered damage, they sued. And they said, this is a violation of our rights to life and to intrusion in our private family life. And the court said, yes, it was. That Turkey should have a proper regulatory system for dealing with potential earthquakes. So you find lots of examples. There's a document on the internet, Cases on Human Rights under the European Convention of Human Rights. And they're just short cases, but you will read in a few hours all these fascinating cases where the court has said that member states who are parties to that convention are breaking their rights to have regard to private and family life. There are also procedures in the Convention about, as in the American Constitution, are no exposure to cruel and unusual punishment. Well, guess how that was vindicated? This guy was in prison, and he says, I have to put up with all the other prisoners smoking. This is exposing me to cruel and unusual punishment, which it probably is, right? And he won. They said you can't be exposing prisoners to the air pollution caused by the others. This is exposing him to cruel and unusual punishments. There were cases about length of proceedings. How long does it take you to get a remedy? Because in some countries, they are notorious, it can take you 10, 12, 14 years to get a remedy. If the public authorities or the government doesn't want you to have a remedy, they can delay it and delay it and delay it. And the European Court has said, European Court of Human Rights has said, you must provide people with an effective remedy. And it is not an effective remedy if you allow cases to go on for years and years and years. So this convention has had a huge influence on the jurisprudence and the case laws of member states. And it has an unusual feature, and it is that anybody can sue in the European Court of Human Rights. That is most unusual in international law. In international law, you have states suing states and so on. But under the European Convention, anybody can sue. But they must first, they have a rule called exhaust their local remedies. They must first try to find a remedy in their own national legal system. But the court isn't too fussy about that, really. In the Spanish case, it didn't really insist that you go to the Spanish Supreme Court or whatever. So sometimes it is, sometimes it isn't, but they must first try to get justice at home. If they can't, then they go to the European Convention of Human Rights. So having illustrated to you I said it's part of the law of all, or it has been accepted by 47 states, including all 28 states in the European Union. Some states have gone further and incorporated into their own municipal law. So Ireland and England have done this, for example. So if you were arguing a case in an Irish court, an environmental case or whatever, in addition to saying, for example, that the polluter has violated his emission standards, you would also say, and he has interfered with my rights to family life and all the rest of it. You would add in the European Court of Human Rights as well, because Irish courts are obliged by Irish law, not just international law, to give effect to the European Convention of Human Rights. So when the Lisbon Treaty happened, see, we tried to have a European constitution, and the French and the Dutch wouldn't subscribe to it, so we couldn't have a European constitution. So instead of that, we had the Lisbon Treaty, which is 96% of what was going to be in the Constitution. But you daren't call it a Constitution. But when we did have the Lisbon Treaty, the treaty said that the European Union was going to accede to the European Convention of Human Rights. And therefore, the jurisprudence of the European Convention of Human Rights becomes EU jurisprudence. Now, it had always been that. In its case law, the European Court had said that sources of law were the constitutional traditions of the member states, international law, and so on. And that was international law. So it had always been part of European jurisprudence. But there was an extra commitment to it in the Lisbon Treaty. And then in the Charter of Fundamental Rights, there's a specific Article 37 saying the European Union shall subscribe to a high level of environmental protection. And then there are other rights in the Charter which are word for word the same as those in the European Convention of Human Rights, like the right to private and family life is incorporated in the Charter. So all of this is becoming part of European law. In addition, we have now got a European Social Charter. Not all states are parties to that. The Poles and the British will not subscribe to it. That is giving what we would call in the United States sort of left-wing rights, in a way, rights to join trade unions and things like this. But one of the rights is, or one of the duties in it, that states have a duty to make sure that their citizens are not exposed to human health, to damage to their human health. So then just the final issues I'm going to talk about are the procedural rights. There's an international convention called the Aarhus Convention, and it has 3 procedural rights which the convention itself says are there to ensure a right to an environment. And these are public participation, access to information, and access to justice. Now, in the United States, you've had access to information for a long time. But if you were in Europe or in Eastern Europe, you wouldn't have had an right of access to information. And it would be inconceivable that you could ask the government to force them to give you information. In 1992, I was advising the Latvian government on environmental law. They had to bring their native environmental law up to the standards of EU law as a condition of membership of the EU. This is a true story. So I said, well, how are we going to improve your native law until we know what it is, right? So I said, okay, we're going to write a little book on your law, environmental law in Latvia, right? So I said, we'll start off with air pollution. So I said, where's the Air Pollution Act? And the Air Pollution Act was in the possession of a lady civil servant called Inge Linge, and she would not give it to us. So nobody in the ministry could give us the Air Pollution Act, and she wouldn't give it to us. So we couldn't even start writing the book on environmental law to see what was the baseline that needed improvement. So you know how we got it? We made her a consultant to the project. And in her capacity as a consultant to the project, which cost about $2,000, it's a horrible way of doing things, she provided us with a copy of the air pollution law. So I mean, this you have no concept of what life is like, or was in access to it, how important it is. On public participation, in Ireland, anybody can be under our law. This group here could form ourselves and say we are an NGO today, and we would be recognized by the courts. If you went to Eastern Europe, there isn't a culture of protest. Individuals are afraid to protest for cultural reasons. So they take courage from numbers. NGOs are extremely important in Eastern Europe. They're extremely important everywhere, but they're particularly important in Eastern Europe because of the cultural inability, or the cultural fear of challenging authority, right? So that's the right of public participation. And access to justice. Access to justice, which is the right to vindicate environmental rights. And remember, I've been talking about a right to the environment, but there is also a right of the environment. And Oliver Stone's Have Trees Standing. We are now evolved to a stage that in Europe, trees almost have standing, because people have a right under the Aarhus Convention of access to justice to enforce environmental laws. Right? And the European Court has said that this access to justice must be such that the costs of suing must not be prohibitively expensive. Now, I work for a big law firm, and the cost of bringing an environmental case would be about $80,000 a day, right? It is prohibitively expensive. It is awful, right? The European Court said you can't have it this way. So it has made a number of rulings where we are evolving towards a situation, not so much in Ireland yet for other reasons, where there must be some sort of provision for assistance to NGOs in environmental cases. We haven't quite got there yet, but it is evolving towards a state where there will be some sort of assistance to NGOs in environmental cases. And the court has already said that the costs of filing papers and things like this shouldn't be too expensive. The English courts have invented a way of saying, putting a cap on costs in order to implement ours. And they've said the maximum cost that will be involved in this case will be £20,000, which will be about 25,000 euros, right? So if you're going to a case knowing that the most it could cost you was 25,000, that's not too bad. If you're going into a case like you would in Ireland, where the maximum might be 500,000, that is a different thing, right? But that is the worst part. In Europe, they passed 2 directives, one on access to information, one on access to public participation, but they could not get the member states to agree on legal costs because of how important and how powerful lawyers are in some member states. They wouldn't allow anything to be done on that. So that is my whistle-stop tour through to my presentation, which in fact I couldn't open the right one and I would have bored you too much if I started looking for it. So that is, if I'd like to answer any questions you might have on this evolution of the right. Oh, just one.
So please raise your hand if you have a question, and I'll bring the microphone over, and Courtney will as well.
Thank you so much for your presentation. As you mentioned earlier on, there is definitely a high level of intrusiveness in terms of the EU court's decisions on the national legal systems and the national administrative systems that they require. I'm just wondering what sort of enforcement mechanisms there are. How does the EU court make sure that Russia, for example, does enact a regulatory system to prevent another occurrence of that accident after issuing that decision?
That's a very good question, because the European Court of Human Rights is an international court, and it doesn't really have power to make the state do things. It makes a judgment, but it can't fine it or impose any penalties. But there's a certain sisterhood and brotherhood in these international states, you know, so it is not good if a state doesn't comply with its European judgment. And you might have NGOs, for example, in Ireland, we had a judgment making, saying the European Court of Human Rights said that making sex between gay people illegal was a violation of the convention. And our government did nothing because we had a very conservative government which didn't want to do it. And then the NGOs started agitating. And a few years later, they brought in a law removing that penalty. But that's just the European Court of Human Rights. The important thing is that that jurisprudence and those rights have now been brought into EU law. In EU law, if the European Court in Luxembourg makes a judgment, it is binding on member states who can be fined for not complying with it. And if they can be brought back to court for not complying with it. And if they don't comply the second time, a bigger fine. And the fines will be 100 million or 200 million, really big fines, and daily fines, right? And the other thing is that in EU law, because the EU has brought in very good regulatory systems for the environment, right? And in each member states, we can all enforce those environmental rights in our member states. So the traditional weaknesses of enforcement are met once European Convention rights are put into European rights. Yeah. Yes, John? Okay.
Thank you for being here, and thank you for speaking. You could have read the phone book, and I would have enjoyed listening to your voice. So,
Oh, thank you.
but the substance added a great deal as well. I was curious in listening to you about the relationship between the rights that you were describing and the court's enforcement of those rights, and the underlying system of environmental protections, the code, the regulations.
Yeah.
So, for example, in your example about the noise levels created by a highway, I would have imagined that the claim might have been met with an argument that, well, the government has set noise standards. We have noise standards.
Yeah.
And we've gone through a very elaborate scientific analysis, and we've done a lot of public participation, and we've weighed costs and benefits, and we've come up with this standard. And the court should defer to this carefully considered standard and not go off on its own and exercise what seemed like common law powers to come up with its own standard and override the outcome of the regulatory process. So I'm just curious how these sort of very important but somewhat general rights that you've described and the judicial enforcement of those rights relates to the more traditional regulatory system that exists in the EU.
Yeah, well, you've identified something, because there was a case about noise from Heathrow. And the people, if any of you have ever stayed in Fulham in London, you'll hear the planes, and it's really noisy. And the European Court of Justice, Human Rights said, oh yes, there's a lot of noise from Heathrow, but the English authorities have investigated this matter, taken all the appropriate measures, and they really questioned them on all the appropriate measures. You know, had they noise limits for nighttime? Had they flight paths in a particular direction? Did the planes have hush kits and all sorts of things like this, right? And they made the English authorities prove that they had taken the very best measures they could, all practicable measures to reduce it. And then said that this was a matter for the discretion of the member states, that you leave them a wide margin of discretion. But they didn't do it for the noise limits. Maybe that country, I don't actually remember the detail, but maybe that country didn't have proper noise limits for motorways. Like we didn't have them in Ireland for motorways. And I know there are places, if people knew, they could get baffle banks and things on their motorways because we didn't have the right standards for them. So you identified, that is normally what the court would say. It would say that once the member state can show that it has taken all practicable measures, they would leave it to their discretion. But if they can't show they've taken all practicable measures, so if we're advising airports now, we have to tell them, you must show you're taking all practicable measures. And at this very moment, we are advising Dublin Airport, and we tell them, you know, there's no Irish system requiring compensation for people who are exposed to aircraft noise. But so you must voluntarily, not by law, you must voluntarily undertake and tell people you will triple glaze their windows, you know, and do all of these voluntary things, so that if it ever does get to the European Court of Human Rights, or even to the EU Court, you will be able to show you took all practicable measures. But you're right, I mean, that is normally, they do defer to the discretion. But if they have a bad system, look at the Russians about the tailings pond. It was a bad system. They weren't monitoring. There was a Greek case about a mine, an open cast lignite mine. And the Greeks had no monitoring. They said, you must have monitoring. You must have a system that ensures respect for these rights.
Okay, other questions?
Thanks so much for your talk. From what you've said, it looks as though existing instruments are being interpreted to allow for protection of human rights with respect to the environment. At the beginning of your talk, you mentioned that there's this move to create a new instrument, a convention on the right to healthy environment. So would you address a bit why a new instrument might be needed when it appears that not just under the European Convention, but the Inter-American Convention and array of other instruments and venues, it seems as though this right may already exist.
Yeah. Well, there's nothing like clarity, Stephanie, It's much better to have it up there, and the fact that it is there creates a moral imperative to address it and try and vindicate it. And for example, the right to water and sanitation has only been a UN right since 2009, right? And I actually worked on that right. But since it was, the UN accepted it as a human right in 2009. The European community has this capacity for individual petitions. And if more than 1 million people from 7 countries petition for something, they have to act upon it, right? And 1.6 million people petitioned for rights to water and sanitation as accepted by the UN, right? Which is fantastic, right? So even before, the UN will have it ratified or whatever, it will be accepted in EU law that there's a right to clean water and sanitation. So I actually think it's very good to have it clarified. Otherwise, you have too many disputes about what it includes and what it doesn't. Yeah.
Anyone else?
Yeah.
So I'm curious if there's a tension in the European jurisprudence between claims of private property rights and rights to environmental protection. You cited one of the property protective provisions of the EU Constitution and said it was actually provided a basis for affirmative environmental protections. And I think that's an interesting example. But in the United States, often the right to or the interest in a healthy environment is in juxtaposition or in conflict with claims of private property owners. And the argument is that environmental protection efforts go to the point of violating companies or individuals' private property rights. And those private property rights can act as a defense against intrusive regulations. And I'm just curious if the European Court of Justice has, in focusing on the property provisions of your Convention on Human Rights, has to any extent developed those provisions as an obstacle to environmental protection, the way our courts in the United States have interpreted the takings clause. As
I know. We have that tension as well, but it's a funny thing. It hasn't really surfaced very much. And on the whole, as long as it's justified for the public good and welfare and proportionate, you are allowed to override private property rights. And in one case, for example, the European Court said mere adverse consequences on a third party are not sufficient to override the first party's right to have an environmental impact statement. It was a case where it was a quarry and there was it was the renewal of a license for a quarry after 30 years. And the regulatory authority didn't ask for an environmental impact statement. This woman, Mrs. Wells, said there should be an environmental impact statement for this. And it was held that there should be. But the quarry owner said, this is really unfair. It's not my fault that this didn't happen and you're intruding in my rights. The court said mere adverse consequences in third party are not more important than the necessity to implement EU law. I've actually been very interested in that area myself, John, and did a lot of research in it because in my country, the state abuses compulsory purchase rights. So we have examples where the state bought property saying it needed it for public purposes, i.e. a sports stadium, didn't use it for those purposes, and sold it at a huge profit, 8 times the price, a year later to somebody else. And in retrospect now it looks like it was a corrupt prime minister who was passing it on to his friend by saying, I'd say we need it for a sports stadium, we'll CPO it. 2 years later they say, we won't have the sports stadium. The guy who was compulsory purchase said, I'll give you back the money, give me back my land. They said, no, we can't do that. The court said, no, we can't do that. And as a result, the financial services sector was built, but injustice was done to one person, you know. I am quite negative on how public authorities behave in terms of acquiring public lands for public purposes, you know. I think maybe, you know, because there was a case, Sparang and Lonring, and in that case, they blighted an area in Stockholm for something like 14 or 15 years. They said, oh, we're going to put a motorway here. And because they had zoned it, as it were, for the motorway, the land was almost unsaleable. And the Court of Human Rights said that that was a violation of property rights. It was disproportionate. They should have done it quicker than, you shouldn't have left the person, you know, in that ambiguous situation for so long.
Okay, we have another question back here.
Really pleased to get this Irish perspective because it bridges the common law perspective, which is very familiar in this country, with the civil law tradition that informs European law. And I want to throw something by you and just get your reaction. American law is notoriously hostile to the idea of positive rights in environmental law and elsewhere. And just a quick couple of examples, the United States does not recognize an affirmative right for the government to intervene when private violence happens. DeShaney versus Winnebago County Social Services is an example. But in Vermont and in other states that have interpreted their state constitutional promises of an efficient or an effective education, what has taken the place of positive rights, at least in the setting of educational entitlements, is a right to equal funding or to some kind of equality principle. I wonder if there's a way to import this notion of equality through the promises of affirmative environmental rights under the European Social Charter.
Well, in the Social Charter, it actually says that states have an obligation to remove dangers to people's health. It actually says that, you know.
But to the extent that there are, well, at least for the time being, at least when member state, would Brexit have any impact on Britain's?
Well, you see, our European journey is really stalled at the moment because you have a lot of resistance from Britain. We're a bit afraid of the Poles and the Czechs, the Danes, and it's at a very delicate phase at the moment, right? And the British have some good things to say. It's mirrored in what happened here in the United States, saying too much immigration because of, you know, right, everybody can move throughout the Union, and too much regulation. There is too much regulation. You know, there's something like 1,950 environmental laws, you know. You don't need that many. They could consolidate them and streamline them and things like this. And it's very confusing, and the burden of administration is much worse in small countries than big countries. In the United States, in the United Kingdom, they have 170 lawyers in the EPA. We have one in our EPA, you know. So some states are really resenting the burden of too much regulation. And that's a lesson that the union has to learn, you know. But so there's a bit of a crisis, you know, about, like the British would be less environmental than the Irish, for example, because they don't like others telling them how to do things.
Okay, with that, we're going to need to wrap it up and let people go. But this was excellent. Thank you, Professor Scannell.